Hello. I want to talk to you about heir property and what to do if you want to sell the heir property but others don't. I'm attorney Vernita Williams. I practice law here in South Florida. I've had the opportunities to work with a lot of families, and sometimes we have heir property challenges. Now, I'm sure most of you know what heir property is. It's property that was owned by your mother and father, or maybe your grandmother and your grandfather, and they've passed away, and now all of their descendants or children and grandchildren own that property. Now, we all know when you have so many owners that the heir property situation can be very, very challenging. We know that. It's because, sometimes you have certain family members who are paying the property taxes, they're doing repairs, they're cutting the grass, they're doing all the upkeep, and then sometimes you have family members who are living there for free, but they may not be willing to do some of these other things that cost money. So maybe you're in a situation where you say, okay, I'm a co-owner of this heir property, but I really am very, very tired of this, and I want to sell it, but I'm stuck because the other owners don't want to sell it. You might have been talking to them about it for years, and they still don't want to sell it. Maybe they're living there for free, and that's why they don't want to sell it, or maybe there are sentimental reasons. Whatever the case, you may want to sell and they don't. So let me just give you 4 little tips on things that you can do if you are a part owner and you want to sell but the other people don't. Number 1, you need to determine who all of the co-owners are. That might be somewhat of a difficult task if it's been decades and decades since the owners on the deed to that property have died. But you need to get a probate attorney, and you need to figure out who are the owners. Now, let me caution you, just because somebody has died, that doesn't mean that they are no longer an owner. So that's why I'm telling you, get a probate attorney, do you a family tree to the best of your ability, and sit with that probate attorney and figure out who actually owned that property. Look at the deed to that property and figure out who are the descendants of those people on the deed to that property, and that will let you know who owns the property. That's the first step. The second step is you need to do something to declare who the owners are. Your attorney might tell you, do probate, put the property in all the names of the living people and even the estates of those owners who have passed away, but you've got to declare who the owners are. And then the third thing, you may wish to involve them in a partition action. And I'll explain what that is now. If people co-own property and one of the co-owners wants to sell, you have a right to go to court and do something called a partition action, in which the court will force the sale of a property. Now, I know, if you're the one who wants to sell and other people don't want to sell, you might have kind of a bad name for doing a partition action. But if you really don't want to be stuck, you need to get your probate attorney, figure out all the co-owners, declare who you think the co-owners are, and go to that third step, do a partition action. Now, this partition action will involve all of the co-owners. And those people who've been sitting on the fence saying, I kind of maybe want to sell, I don't know, they'll have to make a decision and participate in the lawsuit called the partition action. And this way, you get to force the sale of the property. Nobody can sit there and say, I'm not going to sign this and I'm not going to sign that, because a partition action is generally something that they can't avoid. If you initiate an action, then they're going to have to participate. If they don't want to participate, then their little part ownership will just be sold, and they will be given their part of the money based upon how much of an ownership interest they have. The fourth thing is to stay the course. A partition action could be long, it could be messy, it could be adversarial, but if you want to not own this property anymore, you are going to have to stay the course, For the duration of the case, you got to keep at it. You got to go to the next hearing. You got to do the next thing. You got to put the property on the market. A lot of times you're going to have to get a court order to put it on the market, but you have to put it on the market, get some potential buyers, go back to the court and say, hey, court, these are the potential buyers. Authorize the sale to one person when the property is sold. Okay, court, the property is sold. Put the money in your attorney's trust account or in the court registry. Okay, court, here's the money from the sale. Here is how we propose that it be divided up. Give us an order to divide the money. So you don't have to remain stuck. But if you don't want to be stuck keeping the property when you want to sell, you're going to have to be determined to do something about it. Because if folk don't want to sell, either because they live there for free or because they just have sentimental value, but they're not, contributing to paying the property taxes and the maintenance and the upkeep and buying insurance, then do a partition action and get it sold. This is Attorney Vernita Williams. If you would like more information about probate matters or estate planning matters, please visit my website at vcwlaw.com, or you can call me or text me at 786-831-9483.